all-party consent
Okay.
to waive something because of time or whatever.
Yeah, because I was under the impression that obviously the Law Amendments Committee was, because obviously me as a member of the general public, I'm not allowed to go into the legislature and debate with the MLAs. So the only opportunity that I have to bring up any issue I might have with the bill is obviously through my MLA or through the law committee, whether it's public, because I've been reading all about your on the website and stuff. But obviously, but if a bill it goes through first reading, second reading, and skips the law amendment committee, then as a member of the public, I don't have an opportunity to lend my voice to my MLA about that bill. And would that not be skipping a little bit of the democratic process?
Okay, you may have to get into something like that with one of the lawyers, but Nova Scotia in particular it's one of the few places that does have law amendments.
Yes.
So, but as soon as a bill is introduced, anyone is welcome to notice or get hold of their MLA and put forth their comments that way, because that MLA may end up bringing it up in the House. You may give them some ideas for debate.
Yeah. Oh no, absolutely. Because I'm looking here, because obviously I'm looking at the law amendments, and obviously it says after public bills have received second reading in the House, the Standing Committee on Law Amendments give them a clause-by-clause consideration and hears representations from any interested persons or organisations. So you would actually give a date to say that obviously we can give by this date. But I'm just wondering why, because I'm just looking at a couple that were passed through recently, and they completely skipped the Law Amendments Committee, and they were passed through first reading, second reading, all the way through to royal assent in 10 or 15 minutes. And I'm just wondering how that is preserving the democratic process, because it says at the very start on the legislature, it says that obviously the democratic process is that we as a general public, we have that right to be able to be involved in the democratic process. But if a bill is passed, and it's passed within 10 or 15 minutes, and it skips the Law Amendment Committee, then how is that legal? Because I can't see it anywhere.
Okay. Yeah. No, that's an interesting question. I'd rather one of the lawyers would be able to explain that.
Yeah.
Because you may have seen the Appropriations Act, which it's just a listing of all the money that the government's going to give to the departments.
No, what I'm talking about here in particular is the Protecting the Access to Health Services Act, which was introduced by Brad Johns, and obviously, I mean, he's also the chair of the Law Amendments Committee, which yes. I'm not sure if that could be seen as a conflict of interest, but obviously he introduced the bill, but this had first reading on March the 24th, second reading March the 24th, second reading passed March the 24th, skipped the Law Amendments Committee completely, third reading March the 24th, third reading passed March 24th, royal assent March 24th, amendments March the 24th. So this was actually passed within, I believe it was like 15 minutes. But my question is, and again, and I'm not looking for legal advice, I'm not looking for anything. I'm asking questions as a concerned Nova Scotia citizen, really, because I want to live in a democratic province. I want to live where the rule of law is abided by and is respected. And I've looked and I haven't seen any other amendment to a bill that doesn't have a Law Amendment Committee date on it that has gone to royal assent. I'm not talking about ones that were first reading, second reading, etc. But I'm talking ones that have hit. And I've clicked on all of them from the Legislative Assembly. So all I'm looking for is just to be pointed in the right direction of where I can see how this was legal, because I genuinely can't see how it was if it skipped the Law Amendments Committee, because I, as a citizen of Nova Scotia, wouldn't have an opportunity to have my voice heard for anything that I didn't agree with within that bill.
Yeah, I mean, in that one in particular, I think it was a time-sensitive thing. So, in that particular, so like I said, there are reasons, but
that would also, but those reasons would have to be, they would have to be listed in law. They would have to be backed by law. It can't just, we either have hard and fast rules on the legislative process, or it's a wing it as we see fit. And then any of our elected officials basically can do whatever they want. If they say, oh, well, time is of the essence, we either have legislative procedure or we don't. So that's really my concern here as a concerned citizen. So I just wanted to find out where I can find out why this skipped the Law Amendments Committee. Because if it skipped the Law Amendments Committee, then how can it be valid? How can it go to royal assent when it skipped the democratic process?
Okay. Let me see here. Can you hold on?
I'm sorry for bombarding you with this. I know you just picked up the phone and you're like, what the hell is going on?
No. These are questions I get, so don't worry.
Yeah.
I'm just looking to see. There are various. My boss is on vacation. Just one sec. I want to check to see who is.
But do you understand where my concern is coming from?
Oh yes. Oh yeah. No, that's a good question.
Because the thing is, you see, I would have had some comments, I would have had some thoughts that I would have liked to have presented to my MLA, but obviously I can't do that when a bill is absolutely railroaded through the legislature by the Minister of Justice, who's also the head of the Law Amendments Committee.
Yeah, I think in that case that was because I can't remember if that fell under in his jurisdiction, as in.
Well, it would have. Yeah, it would have done because obviously I've checked what falls under the Law Amendments Committee and what falls under the other committee, and this definitely falls under the Law Amendments Committee.
Oh yes, yeah. Okay, just one sec. I'm just going to. Can you hold on?
I absolutely can.
Okay, because I can. Let me see here. I'm going to transfer you to one of the lawyers. So I'm just going to see if I can get hold of her. Can you hold on a moment?
Of course I can. Thank you very much. Appreciate your time on it.
Thank you. Thanks.
Just asking questions.
What a clown world.
Yeah, she was lovely though.
Oh, yeah. Yeah.
Because they must be able to point to a legislation or a law that says where the rules of the House can be deviated from, because they're either rules or they are guidelines, and they quite clearly say rules of the House. This is how a bill becomes a law. It has to pass through these definite, and I think we could actually see them as gatekeepers. They have to pass through these gates to be, because otherwise anybody could introduce anything. And like I said to the lady there, time's of the essence. We got to push this through. And we don't live in a dictatorship. We either have democracy or we don't. You can't have a little bit.
I thought that was interesting that we were on one of the only provinces that
has a Law Amendments Committee. Yeah. But it doesn't matter what other provinces have. I don't live in those other provinces. I live in Nova Scotia. And if we have a Law Amendments Committee, then it needs to be utilised.
Hi. Okay.
Hello.
Erin Kinley for you. She's one of the Legislative Council.
Oh, thank you very much.
So you can explain this to her.
I will ask her all my lovely questions. Thank you.
Okay, so you go ahead.
Finley. How are you?
Hi.
Very,
Hello.
very nice to meet you. My name's Gary. Hello. Yeah, I just had some questions, and I'm not really finding the answer anywhere. I'm not sure if you were given a brief overview, but I was just looking to find out how a bill can skip the Law Amendments Committee, because I was looking obviously through the rules of the House, and obviously the rules of the House on how a bill becomes law is quite clearly laid out, and it does state that all bills have to go through either the Law Amendments Committee or the other committee, but the bill that I'm talking about in particular would 100% have to go through the Law Amendments Committee. But it actually didn't. It was introduced by Brad Johns, who is the head of the law, who's the chair of the Law Amendments Committee, which I believe might be a conflict of interest there, and it was passed the same day. So as a member of, as a Nova Scotia resident, I wouldn't have an opportunity to enter into the democratic process and to pass on my concerns or worry about an amendment to a bill, because it was passed in 10 minutes and it skipped a hard and fast rule within how a bill becomes a law. And no one can point me to the legislature rules or laws that say where that step can be skipped.
Okay. So was this the Appropriations Act?
No, not at all. No, this was the Protecting Access to Health and Services Act, which was introduced by Brad Johns, Bill 105, on March the 24th, 2022, and it got royal assent March the 24th, 2022. I believe it was 15 minutes it took to go through first reading, second reading, third reading, but it completely skipped the Law Amendments Committee. Now, I've looked at, I want to say 20 other bills from that same sitting that went to royal assent. Every single one of them has a Law Amendments Committee date.
Yeah.
Because obviously, these are all the gatekeepers, really. The first reading, the second reading, the MLAs, they are our representatives. They're there, not for their voice to be heard, but for their constituents' voice to be heard. It's not about what they want or what they think. It's about it's about hearing our voice, and the Law Amendments Committee hearing our voice, because obviously we can arrange to speak to the Law Amendments Committee about a bill if we can read it and we know what it is, to give our concerns. And then those concerns, I believe, are brought up in the third reading debates. And then any amendments that need to be made from those concerns, if enough people have them, and then it goes through third reading, past royal assent, done. It becomes a law.
Yeah.
Why did this one skip the Law Amendments Committee? And I can't believe that time was of the essence is a valid reason.
Well, so what happens is the rules can be overridden by unanimous consent of the House.
Okay.
And so that's what it would have taken. It would have taken every MLA in the House who was present that day to agree to put it through from first, second to third reading without going through the Law Amendments Committee.
Okay. And where can I see that happened? Yeah, where can I see that happened?
I think you would have to go to Hansard.
You're saying words I don't understand. Hang on. Oh, Hansard debates. There we go. Okay. It's okay. I'm clicking on it. Okay, search Hansard.
Oh, okay.
What was it? Bill 105. Was it Bill 105? Bill 105?
Don't remember the number.
No, I think it was.
Go by the name.
Hang on, I'm looking now. You know what? I'm going to go back. Bill 105, Protecting Access to Health Services Act. So if I go to, I'm clicking on debates, Hansard, sorry, I apologise.
Yeah.
And that one, Bill 105, I'm clicking on it. And that was March the 24th, I believe. Debates and proceedings. And because obviously I've got lots of presenting and reading petitions. Nope, this is this has to do with. Sorry, because I've never used this system before, so you'll have to forgive me. I'm obviously at a loss here. Yes. So this is an act to amend Chapter 24 of Protecting Access to Health Services Act.
Yeah.
This talks about Alexa McDonald was a historic figure, reading tributes to her.
Okay. So first what happens is they introduce the bill, and then they do, they started that day with talking about Alexa McDonald, right? She had recently died.
Yes.
Yeah.
And then they start talking about the Ukraine, people of the Ukraine. Sorry, I'm just...
See, don't go through all these. What we need to do is we have to get down into... So I just went to page 1438, and that's where the bills were introduced.
Okay, Bill 14... Introduction of bills. Enacted, blah, blah, blah. Bill 105, enacted to amend. Okay?
Yeah.
So I'm heading down there now. Sorry. Maybe you can find it before I do. Let's have a race.
Well, you're getting into it. You're getting into it right now. You're going to see Honourable Kim Maslin, and she said, I would like to seek unanimous consent for Bill 105 be put on the order paper under bills for second reading.
Okay.
Okay. And do you see that?
For the sake of record, I note unanimous consent was obtained. Okay. Now, let me ask you a question, because again, maybe you can help me on this, but I don't understand how, because again, obviously I'm not an MLA, so I don't know all of this, but from my own layman's terms, the members of the Legislative Assembly are representatives of their constituents.
Right.
So what would give them the unilateral power to say that we are, as a group of individuals, we are going to skip the democratic process on behalf of our constituents so they don't get to have a say in this bill? That would be definitely 100% skipping the democratic process, because they're saying that we're going to do this on our constituents' behalf, but our constituents have not said that they want us to do this.
Well, I guess it could be argued that the constituents have authorized them to do that because they voted for it. Like Nova Scotia is a little unique in having law amendments.
Yeah, no, I understand that. I know most provinces don't, but obviously that's why Nova Scotia is probably such a wonderful place, because we do have these safeguards in place to ensure that the people actually have a voice in the legislature. Because yes, I understand electing your representative, but they are still your representative. You're not giving them carte blanche powers to say you speak for me at every turn, because if I can go to my MLA about anything and obviously have a concern, have a debate with them and ask them to do certain things, but my concern is that a group of elected representatives of the people, public servants, decided unilaterally that they were going to not follow the in-stone House rules to get this passed through quickly. And that, to me, seems like it was circumventing the democratic process. And I don't think that is good for democracy, personally, because they could turn around and introduce any bill and say, we're going to unanimously vote on this, and then they could introduce a bill that could absolutely do something horrendous to Nova Scotian residents. Now, again, they could, but they shouldn't. But they shouldn't be able to.
No, but you see, it's so rare. I mean, it takes something like this issue, which was, I think, in particular, this one was the people protesting Dr. Strang's house, and everybody, COVID was hot, and everybody was upset.
But
that's what happened.
Yeah, but they still. But I mean, I don't want to get into the absolute right that people have to protest in public, because of course that can never be taken away. It's enshrined within the Constitution, the Bill of Rights, and the Charter of Rights and Freedoms. But my point is that I just wanted to find out where it's written that the Legislative Assembly can do this, because it being a unwritten rule, that to me doesn't cut the mustard. I actually want to see where it is written, where it says that if everyone says that they're going to railroad this through, that they can skip the full democratic process and it doesn't have to go through the Law Amendments Committee. Because this has happened twice with this one bill, where the Law Amendments Committee have been cut out. So,
well, you look at, first of all, I'm going from memory because I don't have the rules in front of me, but I think it's Rule 85 that talks about the suspension of the rules, and they can be suspended by a two-thirds majority, but it has to be on 2 days' notice.
okay, but this wasn't on 2 days' notice.
So that's why, so that's the two-thirds majority. But if it's unanimous consent, it can be done right away. And so the way our rules work is you start, first of all, with the little green book of the rules of the House, right?
Yep.
The next step is the practices and precedents of the House. And so this would fall probably under that, a practice precedent, that the rules can be suspended on unanimous consent immediately.
But again, does that not strike you as undemocratic? Because we obviously elect our representatives, our MLAs. They're obviously in a very rarefied position. But by having this rule enshrined in there, this means that, and I'm not saying that they would, but it gives them the power to, at any point, introduce a bill. They all vote that they will suspend the rules, and then they can bring in any amendment to any bill, any law, which basically means that 1 million people in Nova Scotia are represented by however many MLAs, and I don't know how many MLAs are in the legislature, you'll have to forgive me, but however many MLAs, that basically gives them unilateral dictatorial power to do whatever they want, whenever they want, and that is not a democratic process. So I
wouldn't say it's unilateral because you have to get every single person agreed, and each person comes from their own constituency with their own background and their own voters. So.
We all know. We all know that people's character can be bent and changed on certain promises and things like that. So, but my point is that I, as a Nova Scotia resident, I'm a little perturbed that there is a rule to say that if our elected officials say that they're not going to follow the rules and they all agree on it, and it only needs 2/3. So if 2/3 of them say, we're not going to follow the rules, that they can do whatever they want. And I think that's going to have to, I think we're going to have to, how do we change that rule? How do we petition to have that rule changed? Because that to me is completely undemocratic.
Well, those are the rules that the MLAs have. So in order for it's sort of similar. What happens is in order for the MLAs to change the rules, they have to, write them up the way they want them to be, and then they give 2 days notice, and then on 2 days notice they can do it with a 2/3 majority.
Okay, so where does it? I'm sorry to cut you off. Sorry, because I understood exactly what you were saying. Sorry, I didn't mean to be rude there. Yeah. I'm just trying to find what rule says that they need the 2 days notice.
Because it would be a motion. So I wish I had it in front of me, but I know it's Rule 85.
Okay, Rule 85 says suspension of rule. No rule adopted by the House shall be dispensed with unless by consent of at least 2/3 of the members present. But I'm trying to find where this 2 day that you mentioned is.
Well, that would be when they early in the process, when they start, the first day, when the sitting begins, they do notices of motion. So they would bring a notice of motion. So if you look in the rules under notices of motion, and the wording is something like, I hereby give notice of motion that I am, on 2 days hence, I will introduce the motion to the following effect, and then they read it.
Okay.
And they would read that about they would read whatever my motion might be to change rule number 54 to say the following. And then 2 days later, it would be on the order paper to be debated and addressed.
Okay, so they didn't follow their own House rules because they didn't put the 2 days to basically say we want to not follow the House rules. So they would have had to have done that, and then 2 days later, then it would have been voted on by the House, which would have given possibly the general public an opportunity to say, hang on a second, why are you trying to ignore House rules? If anybody was following the things, but they didn't do that. So then the House rules weren't followed, and that would make this amendment unlawful because the House rules weren't.
Were followed because you only needed 2/3 majority if it's 2 days notice. But if it's unanimous consent, you don't need. You can if it's unanimous consent, you can do it right away, and that's what they did.
Okay, because I don't see that in the House rules. I don't see where it says about unanimous. Let me search unanimous consent.
Well, and I don't think you're going to find it in there because, like I said, that was one of the rules that's one of the practices and precedents of the House.
Okay, but
this is the way.
But that's not a rule. A motion may be made unanimous consent of the House under Rule 32. Okay, so sorry. Again, the only reason I'm asking you these questions is obviously because I don't know this information. I'm just trying to do my own due diligence before I take it any further. A motion may be made under Rule 32. Rule 32 states... There's a lot of rules. This is insane. How do people know all this? Except as provided in the rules, 2 days' notice shall be given of a motion to present a resolution for the appointment of a committee or for placing a question on the order paper. But this rule shall not apply to bills after their introduction or to private bills or to the... So the rule of motion doesn't apply to bills. So the unanimous vote doesn't apply to bills. So they couldn't say we're going to vote on it on a bill. That would be present a resolution or address an order of the House for the appointment of any committee or for placing a question on the order paper. But this rule shall not apply to bills after their introduction. So I'm puzzled at how they could, because that basically means that they can't, they shouldn't be able to do a unanimous vote because it says that this rule, notice of motion, does not apply to bills. So that means that they couldn't vote to railroad it through, and that they couldn't vote to skip the Law Amendments Committee because that would apply to a bill, if I'm not mistaken.
Well, it would be a bill, but again, I keep getting back to it's unanimous consent. And
Yes.
If they have unanimous consent, they can put it through without, and that is what happens with other bills that go through without law amendments.
But my point is that it says a motion may be made by unanimous consent of the House without notice having been given under Rule 32. And Rule 32 states categorically, but this rule shall not apply to bills or to private bills or to times of meeting or adjournments of the House. So Rule 32 for unanimous decisions, like you just said, does not apply to bills, and this was a bill. So they did a unanimous vote, but they shouldn't have done. So that means that bill is invalid because they didn't follow the House rules. They actually violated the House rules. They violated Rule 32.
Yes, but
Yes. There is no but.
Right.
Unfortunately, when it comes to the law, there is no but. We either live by the rule of law or we don't. And these guys just make it up as they go along, and they can do whatever they want. And unfortunately, as a citizen of Nova Scotia, this disturbs me greatly. That I'm looking at these House rules. You told me the rules to look at. I'm looking at them, and I've been through. And the only time that unanimous decision is mentioned is in relation to Rule 32, and Rule 32 clearly states that this rule shall not apply to bills. So how did they circumvent the democratic process by not following the rules of the House? Because surely the Speaker of the House should have said, according to Rule 32, this unanimous vote cannot be put towards a bill. So no, we cannot do this.
Okay, but it can, and the reason I don't think you like the answer, and I think that's what the problem is.
No, it's not about liking or disliking an answer. I just want. All I'm doing is asking questions. I just want to be pointed. All I want is to be pointed to the rule that says they can do this, but the rule says they can't do this. It actually contradicts what you just said. Yes, you said they can do a unanimous according to this rule, But when you look at the rules of the House, it says that yes, they can do this, but it does not apply to bills. And they applied it to a bill.
Okay, because not all the rules are in writing, and if it does, if
they have to be in writing. They have to be in writing. You can't just have rules that people remember, because then somebody could turn around and say, "Oh yeah, no, it's this rule. Well, can I see it? No, don't worry, it's not written down. I've just got it in my mind." That's not how the law works.
Well, it is. Even the common law works that way. There are unwritten rules, and these are the precedents of the House.
There are no unwritten rules. There are no, like, the rules that we follow as a civilized society. I'm not talking about Magna Carta days. I'm not talking about when we used to live by common law. Currently, yes, common law still exists, but we live by the rule of law, the Canadian Criminal Code, etc. And the House rules are written down. These are the rules that they must follow. They violated these rules. Now, somebody saying, "Oh, it's an unwritten rule," that because they could say anything at that point. They could say, "We're going to pass this bill through that taxes Nova Scotians at 90% of their earnings." Yeah, and well, where does it say that? "Oh, it's an unwritten rule." We can't prove to you that it exists. It's just an unwritten rule. That, unfortunately, would if I brought that as a defendant, would that hold up in court? Nope, because it's not worth the paper it's written on, because it's an unwritten rule, which means it has no validity in law.
I'm not sure why you even want to talk to me, because you're not listening. You're just talking. The common law are the unwritten rules, and the way it works is it's not just to be able to say this is an unwritten rule. You have to show the precedent, and that's what would happen in this case. If someone like you is questioning why can they do this with unanimous consent, what we would do is we would find an example of where it's been done in the past that has set a precedent and that's been accepted.
Just because something was done in the past, just because something was done in the past doesn't make it right. We wouldn't bring back slavery. That was done in the past. You know, that doesn't mean it was right or legal. Just because something was done in the past, that could also have been an illegal act. They could have also been doing something wrong at that point. So, you know, people used to beat their wives, but you can't do it these days because it's unlawful. And what I'm trying to get to, and I understand what you're saying, but maybe no one has answered my question yet, but nobody can point me to the law or the rule that is written down, that is enshrined in law, that could be used in a court as evidence to say that they could do this. Because all I'm seeing in the rules of the House is that they couldn't do this. It's going against what you're saying. It's actually proving the opposite, because it quite clearly says in black and white that Rule 32 cannot be used on a bill. But they used it on a bill.
They voted by unanimous consent to suspend the rules, and they're allowed to do that.
But they're not. But they're not allowed to do it. But that's my point. That you're saying that they're allowed to, but if you open up Rule 32, except as provided to these rules, 2 days' notice shall be given as a motion to present a resolution or address an order of the House for the appointment of a committee or for placing a question on the order. But this rule shall not apply to bills or to private bills or to times of meetings or adjournments of the House. It says in black and white that this rule does not apply to bills. So they cannot say, I would like to motion that we railroad this through. The Speaker of the House should have said, no, Rule 32 says that this cannot be applied to bills. But he didn't do that, which means that this bill is invalid because it also shouldn't have skipped the Law Amendments Committee.
Well, there's a few bills that skipped the Law Amendments
And
Committee.
and my point is that they shouldn't have done. They shouldn't have done. That's it. It actually, I mean, I don't know if I would go so far as to say it's illegal, but it's unlawful because it skipped the democratic process. And the rules of the House are the rules of the House.
All elected members. These are all elected members.
Who have to follow the rules of the House, and they didn't follow the rules of the House. see where the unwritten rules are, please?
Well, they're not written, right?
Do you see the problem? Now, if you went in front of a judge and said that, honestly, because you know what, you seem like a nice person, and I promise I'm really not trying to give you a hard time. I genuinely promise I'm not. I'm just as a concerned citizen. I was passed through to you. You obviously know what you're talking about in this situation, and I'm just trying to get to the bottom of this. That if I brought this to court and I said that this rule skipped the legislative procedure and it violated it, and they brought up the rules of the House, and I showed that the rules of the House clearly state that this rule should not be applied to bills, and they turned around, you as defensive counsel said, well, it's the unwritten rules. The judge would say, get out of my courtroom. There's no such thing as unwritten rules.
I would say it's an unwritten rule similar to the common law, and here are precedents from the past where this has been done and accepted.
Yep, and then I would say, and can you show me where that rule says that could happen? And you would go back to, it's an unwritten rule. And then we go in a big circle. And the point is that having an unwritten rule for people who are supposed to be public servants and the elected officials who are representative of the people should not have unwritten rules where they can do what they want when they want because they say it's an unwritten rule. That.
But the point is, the reason that you elect someone is so that they can act on your behalf.
Yes.
So that they can act on your behalf, and then you can come and say, well, you're not doing what I want. This is what I want. You know, they're allowed to override.
How would well let me ask you a question then. How would my elected official be able to act on my behalf when a bill is gone through first reading to royal assent within 15 minutes? I wouldn't have an opportunity for my MLA to hear my voice because he wouldn't know what I was thinking because I'm one of maybe 30,000 people in his constituency. But my voice is just as important as the other 29,999 people, and it's more important than his or her voice because they shouldn't have a voice. They are the elected official.
That's the argument, is that they've been elected to be your voice.
Yes.
They can't. Do you think that they consult with every single constituent on every single bill?
No, not at all. But when they are elected, as the person who elected them, I would be under the impression that they were bound by laws, rules, and regulations that I would be able to articulate in a court of law. And saying that, oh, we did this before, so it's all right, to me, is not a valid argument. And I genuinely do not believe that would stand up in court. Because what we're saying here is that 2/3 of the House could say, we're not gonna follow our own rules, which the people who voted us in knew that we had a set of rules that we had to follow. That'd be like going to a soccer match or a football match, 2/3 of the players saying, you know what, we don't want to follow the referee's rules, and then it goes ahead. We have rules and regulations for a reason. There are no such thing as unwritten rules, unfortunately, because that would mean that people can say what they want when they want and just say, that's an unwritten rule, don't worry about it. We don't work like that. We live under the rule of law, and if those rules of law are not written down and they can't be articulated, then they're not a law. They're not a law.
They might be articulated in a speaker's ruling. It could be that there's speaker's rulings on them, but I don't even know that there is, because I think that it's a precedent of the House. It's an accepted practice, and that's, you know.
When an MLA is elected in, do they have to take an oath of office?
Yes.
Where can I find that oath of office? Because I'd like to see if there's an asterisk in their oath where it says, unless 2/3 of us vote to violate the House rules, and then you're all out of luck.
Well, I think the oath of office most likely is in the House of Assembly Act, and I know there's not an asterisk.
Well, it seems like there is. Well, actually, no, there isn't, because it says in their rules that they can't apply this asterisk to bills, even though they have, obviously, many times. And obviously, as a concerned citizen, and it isn't just me, there's actually a coalition of concerned citizens now with how our MLAs are do swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth. I do affirm that I will be faithful. Oh, that's all they swear. Oh, her hairs according to law, so help me God. So really, they don't swear an oath of allegiance to their constituents. They swear it to the Queen. That's interesting. Okay, well, I think, yeah, I really appreciate all your time on this. I really appreciate you answering my questions and pointing me to the House rules, because that has helped me out a great deal. And I think we're gonna have to go unless there's something else you can point me to, like a book of unwritten rules or something that's written down.
No, I don't think I can. Other than, well, I mean, we written in Hansard, and that's where Hansard would be where you would find other bills that went through with unanimous consent.
Yeah, I'm gonna take, because again, as we know, Rule 32 shouldn't be applied to bills. So I think every single one of them might have to be re-looked at and reintroduced and have to go through the Law Amendments Committee, regardless of how old they are, because I genuinely believe that anything, and I'm proud of Nova Scotia for having the Law Amendments Committee. I really am. I think it's a wonderful thing to have, and I think it really does protect democracy, and it protects people's ability to actually have a voice in the legislature, and have a voice with our elected officials. Because at the end of the day, that is all they are. They are simply there as it is not their own will. It is not their own thing that should be put through in the legislature. It should be the will and the wishes of their constituents. And obviously, they can't go around.
But you have to admit it would be very difficult to live up to the will of every single constituent.
And that is why, and I put it to you that is why the Law Amendments Committee is there. Because then they don't have to knock on everyone's door. It is up to us as informed citizens to read the bills, which I'm sure most people don't, to read the bills and to bring those concerns. That is our burden. That is on us. That is not the MLA's burden, and I'm not trying to put that burden on them. I'm not saying that they have to get a consensus from every single person in their constituents, but as constituents, we have to have an opportunity, and we cannot have that opportunity taken from us by our elected officials to be able to have our voices heard.
But how do you think other provinces work then?
I don't live in other provinces, and I don't care what other provinces do, because I don't live there. And if I did live there, I would obviously have those concerns, and I would ensure that I ran for an MLA, and I would change the system from the inside. But I live in Nova Scotia. And Nova Scotia does have the Law Amendments Committee, and my concern is that the man who introduced the bill is also the chair of the Law Amendments Committee, and it skipped the Law Amendments Committee. So I obviously have some serious concerns here. I have some serious concerns that unwritten rules are being used in the place of actual rules of the House. I'm going to have to speak to my coalition, and then we will decide where we go from here. But you have been a wonderful resource and a wonderful help, and I would like to thank you for your time on this. And I hope you've had a wonderful phone call too.
Well, I'm just curious. Like, is all this because of the Dr. String bill we call it?
Nope. I was just going through, and like I said, I'm a concerned citizen. I don't have many hobbies, but one of my hobbies is holding public officials to a higher order, because at the end of the day, police, public servants, I believe that they should be held to a higher order, because they have decided that they want to be in that position. Nobody forced them. Nobody held them at gunpoint and said, "You're going to be an MLA now. It's your term for 4 years." It's not like jury duty. They chose that position. And if you choose a position like that, then I believe that you should be the holiest of holies when it comes to upholding the law, upholding statutes, and certainly upholding the rules of your job. And that's really where I stand. So, I'm going to take it from here.
Okay.
You have been... Sorry, what was your name again? Sorry, because I completely forgot. Karen. Well, Karen, you have a wonderful day, and I'm sure you're thinking, I hope he never calls again. So.
Well, it's been interesting.
You take care.
I wish I had my rule, Andy. Okay.
Take care.
Bye.
Bye-bye.
course, she's Karen.
Of course, it's a Karen. That lawyer I was talking to, the legislative lawyer. Yeah, did you hear everything she was saying?
Oh yeah. I hope that I recorded it properly.
Yeah. So they have house rules that they have to follow, and they can unanimously vote to suspend certain house rules. But the one rule that they have that they can't is that they can unanimously vote, but that vote can't go towards bills. So I was like, so the very rule that you're saying that they use clearly states that they cannot be used against bills. They cannot supersede the democratic. Well, it's an unwritten rule. So that's not a law.
Well, to me, that is terrifying.
Isn't it?
Yeah.
We've got to, that cannot go. We cannot let this happen. We cannot let this happen where they're like, it's an unwritten rule. And you heard, like, she is obviously a lawyer. She is a legislative lawyer. She goes to court for this shit. She knows this shit inside and out. And I don't know anything.
She couldn't come up with any of the precedents either.
No. Like, does that not strike you as insane? And even when I said to her, Rule 32 quite clearly states that it cannot be used.
I'm gonna stop this recording because we'll just repeat, but yeah, that was really interesting.